This is video 6 in a Miami Condo Investing Club series on House Bill 913 Condominium and Cooperative Associations from the 2025 Florida Legislative Session. Topic: Pages 67 through 79 of the comprehensive 92-page House Bill 913 PDF document released by the Florida Legislature. Introduction. Florida is set to implement changes to the state's overarching condo law beginning July 1, 2025. This new legislation, dubbed House Bill 913 or HB 913, aims to assist cash-strapped condo owners to adapt to the changes being implemented as a result of the tragic Surfside condo collapse in June 2021, when nearly 100 people died and a $1 billion settlement was paid out to the families of the victims. The legislation was passed on April 30, 2025, and signed into law by Florida Governor Ron DeSantis on June 23, 2025. In our effort to stay abreast of the latest trends, opportunities, and challenges in the South Florida condo market, we at the Miami Condo Investing Club have obtained a copy of the new legislation, which is available from the Florida Legislature's website as a comprehensive 92-page PDF document. We plan to make a series of videos highlighting the new legislation for educational purposes. All of our videos will feature AI-generated audio based on the voice of Peter Zaleski, the founder of the Miami Condo Investing Club, reading aloud the legislation verbatim. We hope that our videos will provide viewers and listeners alike a convenient way to listen on demand to the revisions while doing other things, including cooking, exercising, or even gardening. Please note, each video will be less than 60 minutes long in order to facilitate distribution on our website of Miami Condo Club, as well as on popular social media networks. It is also worth noting we will do our best to start and stop the videos based on related topics. However, it is possible that the videos at times may jump around from one topic to another. If this happens, please remember our videos are exact readouts of the text of the House Bill 913 PDF document. This video, the sixth in our series, features pages 67 through 79 of the comprehensive 92-page House Bill 913 PDF document. The text was copied directly from the PDF document and pasted into this video file. No editing was made to the text to create this video. To view the text directly, please visit flsenate.gov/session/bill/2025/913 or alternatively laws.flrules.org/2025/175. If you are seeking independent information, critical analysis, or proprietary research about the South Florida condo market, we would encourage you to consider joining the Miami Condo Investing Club. The club's mission is to foster a community that shares real-time, actionable intelligence on the latest real estate trends, emerging opportunities, and trusted service providers throughout South Florida. Whether you are a do-it-yourself DIY condo buyer or a seasoned real estate professional, the club provides invaluable resources, including up-to-date statistics, expert analysis, and access to tailored consulting services. More information on the club is available at Miami Condo Club. We hope you enjoy video 6 in our series on Florida House Bill 913. This is a readout of pages 67 through 79 of the 92-page House Bill 913 PDF document released by the Florida Legislature. Begin. Section 19. Section 31 of Chapter 2024-244, Laws of Florida, is amended to read: Section 31. The amendments made to SS 718.10314 and 718.2023 and 718.40712 and 6 Florida statutes as created by this Act may not apply retroactively and shall only apply to condominiums for which declarations were initially recorded on or after October 1, 2024. Section 20. Subsection 13 is added to Section 719.104 Florida statutes to read: 719.104 Cooperatives, access to units, records, financial reports, assessments, purchase of leases. 13 Investment of association funds. A board shall, in fulfilling its duty to manage operating and reserve funds of its association, use best efforts to make prudent investment decisions that carefully consider risk and return in an effort to maximize returns on invested funds. B. An association may invest reserve funds in one or any combination of certificates of deposit or in depository accounts at a community bank, savings bank, commercial bank, savings and loan association, or credit union without a vote of the unit owners. Section 21. Paragraphs J and K of subsection 1 of section 719.106 Florida statutes are amended to read 719.106 bylaws, cooperative ownership. 1. Mandatory provisions. The bylaws or other cooperative documents shall provide for the following, and if they do not, they shall be deemed to include the following. J. Annual budget. 1. The proposed annual budget of common expenses must be detailed and must show the amounts budgeted by accounts and expense classifications, including, if applicable, but not limited to, those expenses listed in S. 719.50420. The Board of Administration shall adopt the annual budget at least 14 days before the start of the association's fiscal year. In the event that the Board fails to timely adopt the annual budget a second time, it is deemed a minor violation, and the prior year's budget shall continue in effect until a new budget is adopted. 2. A. In addition to annual operating expenses, the budget must include reserve accounts for capital expenditures and deferred maintenance. These accounts must include, but not be limited to, roof replacement, building painting, and pavement resurfacing, regardless of the amount of deferred maintenance expense or replacement cost, and for any other items for which the deferred maintenance expense or replacement cost exceeds $25,000 or the inflation-adjusted amount determined by the division under subparagraph 6, whichever amount is greater. The amount to be reserved must be computed by means of a formula which is based upon estimated remaining useful life and estimated replacement cost or deferred maintenance expense of the reserve item. In a budget adopted by an association that is required to obtain a structural integrity reserve study, reserves must be maintained for the items identified in paragraph K for which the association is responsible pursuant to the declaration, and the reserve amount for such items must be based on the findings and recommendations of the association's most recent structural integrity reserve study. With respect to items for which an estimate of useful life is not readily ascertainable, or with an estimated remaining useful life of greater than 25 years, an association is not required to reserve replacement costs for such items, but an association must reserve the amount of deferred maintenance expense, if any, which is recommended by the Structural Integrity Reserve Study for such items. The association may adjust replacement reserve assessments annually to take into account an inflation adjustment and any changes in estimates or extension of the useful life of a reserve item caused by deferred maintenance. B. The members of a unit owner controlled association may determine, by a majority vote of the total voting interests of the association, for a fiscal year to provide no reserves or reserves less adequate than required by this subsection. Before turnover of control of an association by a developer to unit owners other than a developer under S. 719.301, the developer-controlled association may not vote to waive the reserves or reduce funding of the reserves. C. For a budget adopted on or after December 31, 2024, a unit owner-controlled association that must obtain a structural integrity reserve study may not determine to provide no reserves or reserves less adequate than required by this paragraph for items listed in paragraph K. If a meeting of the unit owners has been called to determine to provide no reserves or reserves less adequate than required, and such result is not attained or a quorum is not attained, the reserves as included in the budget shall go into effect. D. If the local building official, as defined in S. 468.603, determines that the entire cooperative building is uninhabitable due to a natural emergency, as defined in S. 252.34, the board may pause the contribution to its reserves or reduce reserve funding until the local building official determines that the cooperative building is habitable. Any reserve account funds held by the association may be expended pursuant to the board's determination to make the cooperative building and its structures habitable. Upon the determination by the local building official that the cooperative building is habitable, the association must immediately resume contributing funds to its reserves. 3. AI reserves for the items identified in paragraph G may be funded by regular assessments, special assessments, lines of credit, or loans. A special assessment, a line of credit, or a loan under this subparagraph requires the approval of a majority vote of the total voting interests of the association. Roman 2, a unit owner-controlled association that is required to have a structural reserve study may secure a line of credit or a loan to fund capital expenses required by a milestone inspection under S. 553.899 or a structural integrity reserve study. The lines of credit or loans must be sufficient to fund the cumulative amount of any previously waived or unfunded portion of the reserve funding amount required by this paragraph and the most recent structural integrity reserve study. Funding from the line of credit or loans must be immediately available for access by the board to fund required repair, maintenance, or replacement expenses without further approval by the members of the association. A special assessment, a line of credit, or a loan secured under this subparagraph and related details must be included in the annual financial statement required under S. 719.1044 to be delivered to unit owners and required under S. 718.503 to be provided to prospective purchasers of a unit. B. For a budget adopted on or before December 31st, 2028, if the association has completed a milestone inspection pursuant to S. 553.899 within the previous 2 calendar years, the board, upon the approval of a majority of the total voting interests of the association, may temporarily pause, for a period of no more than 2 consecutive annual budgets, reserve fund contributions, or reduce the amount of reserve funding for the purpose of funding repairs recommended by the milestone inspection. This subparagraph does not apply to a developer-controlled association and an association in which the non-developer unit owners have been in control for less than 1 year. An association that has paused reserve contributions under this subparagraph must have a structural integrity reserve study performed before the continuation of reserve contributions in order to determine the association's reserve funding needs and to recommend a reserve funding plan. 4. Reserve funds and any interest accruing thereon shall remain in the reserve account or accounts and shall be used only for authorized reserve expenditures unless their use for other purposes is approved in advance by a vote of the majority of the total voting interests of the association. Before turnover of control of an association by a developer to unit owners other than the developer under S. 719.301, the developer may not vote to use reserves for purposes other than that for which they were intended. For a budget adopted on or after December 31st, 2024, members of a unit owner-controlled associations that must obtain a structural integrity reserve study may not vote to use reserve funds or any interest accruing thereon for purposes other than the replacement or deferred maintenance costs of the components listed in paragraph K. 5. An association's reserve accounts may be pooled for 2 or more required components. Reserve funding for components identified in paragraph G may only be pooled with other components identified in paragraph G. The reserve funding indicated in the proposed annual budget must be sufficient to ensure that available funds meet or exceed projected expenses for all components in the reserve pool based on the reserve funding plan or schedule of the most recent structural integrity reserve study. A vote of the members is not required for the board to change the accounting method for reserves to a pooling accounting method or a straight line accounting method. 6. The division shall annually adjust for inflation based on the Consumer Price Index for all urban consumers released in January of each year, the minimum $25,000 threshold amount for required reserves. By February 1st, 2026, and annually thereafter, the division must conspicuously post on its website the inflation-adjusted minimum threshold amount for required reserves. K. Structural Integrity Reserve Study. 1. A residential cooperative association must have a structural integrity reserve study completed at least every 10 years for each building on the cooperative property that is 3 habitable stories or higher in height, as determined by the Florida Building Code. That includes, at a minimum, A study of the following items as related to the structural integrity and safety of the building. A. Roof. B. Structure, including load-bearing walls and other primary structural members and primary structural systems, as those terms are defined in S. 627.706. C. Fireproofing and fire protection systems. D. Plumbing. E. Electrical systems. F. Waterproofing and exterior painting. G. Windows and exterior doors. H. Any other item that has a deferred maintenance expense or replacement cost that exceeds $25,000 or the inflation-adjusted amount determined by the division under subparagraph J6, whichever is greater, and the failure to replace or maintain such item negatively affects the items listed in subparagraphs A, G, as determined by the visual inspection portion of the Structural Integrity Reserve Study. 2. A structural integrity reserve study is based on a visual inspection of the cooperative property. 3. A structural integrity reserve study, including the visual inspection portion of the structural integrity reserve study, must be performed or verified by an engineer licensed under Chapter 471, an architect licensed under Chapter 481, or a person certified as a reserve specialist or professional reserve analyst by the Community Associations Institute or the Association of Professional Reserve Analysts. B. Any design professional as defined in S. 558.027 or contractor licensed under Chapter 489 who bids to perform a structural integrity reserve study must disclose in writing to the association his or her intent to bid on any services related to any maintenance, repair, or replacement that may be recommended by the Structural Integrity Reserve Study. Any design professional as defined in S. 558.002 or contractor licensed under Chapter 489 who submits a bid to the association for performing any services recommended by the Structural Integrity Reserve Study may not have an interest, directly or indirectly, in the firm or entity providing the association's Structural Integrity Reserve Study, or be a relative of any person having a direct or indirect interest in such firm, unless such relationship is disclosed to the association in writing. As used in this section, the term relative means a relative within the third degree of consanguinity by blood or marriage. A contract for services is voidable and terminates upon the association filing a written notice terminating the contract if the design professional or licensed contractor failed to provide the written disclosure of the relationship required under this paragraph. A design professional or licensed contractor may be subject to discipline under the applicable Practice Act for his or her profession for failure to provide the written disclosure of the relationship required under this subparagraph. 4A.3. At a minimum, a structural integrity reserve study must identify each item of the cooperative property being visually inspected, state the estimated remaining useful life, and the estimated replacement cost or deferred maintenance expense of each item of the cooperative property being visually inspected, and provide a reserve funding schedule with a recommended annual reserve amount that achieves the estimated replacement cost or deferred maintenance expense of each item of cooperative property being visually inspected by the end of the estimated remaining useful life of the item. The Structural Integrity Reserve Study may recommend that reserves do not need to be maintained for any item for which an estimate of useful life and an estimate of replacement cost cannot be determined, or the study may recommend a deferred maintenance expense amount for such item.
At a minimum, the Structural Integrity Reserve Study must include a recommendation for a reserve funding schedule based on a baseline funding plan that provides a reserve funding goal in which the reserve funding for each budget year is sufficient to maintain the reserve cash balance above zero. The study may recommend other types of reserve funding schedules, provided that each recommended schedule is sufficient to meet the association's maintenance obligation.
B. The Structural Integrity Reserve Study may recommend that reserves for replacement costs do not need to be maintained for any item with an estimated remaining useful life of greater than 25 years, but the study may recommend a deferred maintenance expense amount for such item. If the Structural Integrity Reserve Study recommends reserves for any item for which reserves are not required under this paragraph, The amount of the recommended reserves for such item must be separately identified in the Structural Integrity Reserve Study as an item for which reserves are not required under this paragraph. C. The Structural Integrity Reserve Study must take into consideration the funding method or methods used by the association to fund its maintenance and reserve funding obligations through regular assessments, special assessments, lines of credit, or loans. If the Structural Integrity Reserve Study is performed before the association has approved a special assessment or secured a line of credit or a loan, the Structural Integrity Reserve Study must be updated to reflect the funding method selected by the association and its effect on the reserve funding schedule, including any anticipated change in the amount of regular assessments. The Structural Integrity Reserve Study may be updated to reflect any changes to the useful life of the reserve items after such items are repaired or replaced, and the effect such repair or replacement will have on the reserve funding schedule. The association must obtain an updated Structural Integrity Reserve Study before adopting any budget in which the reserve funding from regular assessments, special assessments, lines of credit, or loans do not align with the funding plan from the most recent version of the Structural Integrity Reserve Study. 5. This paragraph does not apply to buildings less than 3 stories in height. Single-family, two-family, three-family, or four-family dwellings with 3 or fewer habitable stories above ground, any portion or component of a building that has not been submitted to the cooperative form of ownership, or any portion or component of a building that is maintained by a party other than the association. 6. Before a developer turns over control of an association to unit owners other than the developer must have a turnover inspection report in compliance with S. 719.3014P and Q for each building on the cooperative property that is 3 stories or higher in height. 7. Associations existing on or before July 1, 2022, which are controlled by unit owners other than the developer, must have a Structural Integrity Reserve Study completed by December 31, 2024, for each building on the cooperative property that is 3 stories or higher in height. An association that is required to complete a milestone inspection on or before December 31, 2026, in accordance with S. 553.899, may complete the Structural Integrity Reserve Study simultaneously with the milestone inspection. In no event may the Structural Integrity Reserve Study be completed after December 31, 2026. 8. If the milestone inspection required by S. 553.899 or an inspection completed for a similar local requirement was performed within the past 5 years and meets the requirements of this paragraph, such inspection may be used in place of the visual inspection portion of the Structural Integrity Reserve Study. 9. If the association completes a milestone inspection required by S. 553.899 or an inspection completed for a similar local requirement, the association may delay performance of a required Structural Integrity Reserve Study for no more than the 2 consecutive budget years immediately following the milestone inspection in order to allow the association to focus its financial resources on completing the repair and maintenance recommendations of the milestone inspection. 10. If the officers or directors of an association willfully and knowingly fail to complete a Structural Integrity Reserve Study pursuant to this paragraph, such failure is a breach of an officer's and director's fiduciary relationship to the unit owners under S. 719.1049. An officer or a director of the association must sign an affidavit acknowledging receipt of the completed Structural Integrity Reserve Study. 11. Within 45 days after receiving the Structural Integrity Reserve Study, the association must distribute a copy of the study to each unit owner or deliver to each unit owner a notice that the completed study is available for inspection and copying upon a written request. Distribution of a copy of the study or notice must be made by United States mail or personal delivery at the mailing address, property address, or any other address of the owner provided to fulfill the association's notice requirements under this chapter, or by electronic transmission to the email address or facsimile number provided to fulfill the association's notice requirements to unit owners who previously consented to receive notice by electronic transmission. 12. Within 45 days after receiving the Structural Integrity Reserve Study, the association must provide the division with a statement indicating that the study was completed and that the association provided or made available such study to each unit owner in accordance with this section. Such statement must be provided to the division in the manner established by the division using a form posted on the division's website. 13. The division shall adopt by rule the form for the Structural Integrity Reserve Study in coordination with the Florida Building Commission. Section 22. Paragraph I of subsection 1 of section 719.128 Florida statutes is amended to read: 719.128 Association Emergency Powers. 1. To the extent allowed by law, unless specifically prohibited by the cooperative documents and consistent with S. 617.0830, the Board of Administration, in response to damage or injury caused by or anticipated in connection with an emergency, as defined in S. 252.344, for which a state of emergency is declared pursuant to S. 252.36 in the area encompassed by the cooperative, may exercise the following powers. I require the evacuation of the cooperative property in the event of an evacuation order in the area in which the cooperative is located, or prohibit or restrict access to the cooperative property in the event of a public health threat. If a unit owner or other occupant of a cooperative fails or refuses to evacuate the cooperative property for which the board has required evacuation, the association is immune from liability for injury to persons or property arising from such failure or refusal. Section 23. Subsection 3 of Section 719.501 Florida statutes is amended. Paragraph C is added to subsection 2 of that section, and subsection 1 of that section is reenacted to read: 719.501 Powers and Duties of Division of Florida Condominiums, Timeshares, and Mobile Homes. 1. The Division of Florida Condominiums, Timeshares, and Mobile Homes of the Department of Business and Professional Regulation, referred to as the Division in this part, in addition to other powers and duties prescribed by Chapter 718, has the power to enforce and ensure compliance with this chapter and adopted rules relating to the development, construction, sale, lease, ownership, operation, and management of residential cooperative units. Complaints related to the procedural completion of the Structural Integrity Reserve Studies under S. 719.1061K, and complaints related to the procedural completion of milestone inspections under S. 553.899. In performing its duties, the division shall have the following powers and duties. The division may make necessary public or private investigations within or outside this state to determine whether any person has violated this chapter or any rule or order hereunder, to aid in the enforcement of this chapter, or to aid in the adoption of rules or forms hereunder. B. The division may require or permit any person to file a statement in writing, under oath or otherwise, as the division determines, as to the facts and circumstances concerning a matter to be investigated. C. For the purpose of any investigation under this chapter, the division director or any officer or employee designated by the division director may administer oaths or affirmations, subpoena witnesses and compel their attendance, take evidence, and require the production of any matter which is relevant to the investigation, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of relevant facts or any other matter reasonably calculated to lead to the discovery of material evidence. Upon failure by a person to obey a subpoena or to answer questions propounded by the investigating officer, and upon reasonable notice to all persons affected thereby, the division may apply to the circuit court for an order compelling compliance. D. Notwithstanding any remedies available to unit owners and associations, if the division has reasonable cause to believe that a violation of any provision of this chapter or related rule has occurred, the division may institute enforcement proceedings in its own name against a developer, association, officer, or member of the board, or its assignees or agents, as follows. 1. The division may permit a person whose conduct or actions may be under investigation to waive formal proceedings and enter into a consent proceeding whereby orders, rules, or letters of censure or warning, whether formal or informal, may be entered against the person. 2. The division may issue an order requiring the developer, association, officer, or member of the board, or its assignees or agents, to cease and desist from the unlawful practice and take such affirmative action as in the judgment of the division will carry out the purposes of this chapter. Such affirmative action may include, but is not limited to, an order requiring a developer to pay monies determined to be owed to a condominium association. 3. The division may bring an action in circuit court on behalf of a class of unit owners, lessees, or purchasers for declaratory relief, injunctive relief, or restitution. 4. The division may impose a civil penalty against a developer or association or its assignees or agents for any violation of this chapter or related rule. The division may impose a civil penalty individually against any officer or board member who willfully and knowingly violates a provision of this chapter, a rule adopted pursuant to this chapter, or a final order of the division. The term willfully and knowingly means that the division informed the officer or board member that his or her action or intended action violates this chapter, a rule adopted under this chapter, or a final order of the division, and that the officer or board member refused to comply with the requirements of this chapter, a rule adopted under this chapter, or a final order of the division. The division, prior to initiating formal agency action under Chapter 120, shall afford the officer or board member an opportunity to voluntarily comply with this chapter, a rule adopted under this chapter, or a final order of the division. An officer or board member who complies within 10 days is not subject to a civil penalty. A penalty may be imposed on the basis of each day of continuing violation, but in no event shall the penalty for any offense exceed $5,000. The division shall adopt, by rule, penalty guidelines applicable to possible violations or to categories of violations of this chapter or rules adopted by the division. The guidelines must specify a meaningful range of civil penalties for each such violation of the statute and rules, and must be based upon the harm caused by the violation, upon the repetition of the violation, and upon such other factors deemed relevant by the division. For example, the division may consider whether the violations were committed by a developer or owner-controlled association, the size of the association, and other factors. The guidelines must designate the possible mitigating or aggravating circumstances that justify a departure from the range of penalties provided by the rules. It is the legislative intent that minor violations be distinguished from those which endanger the health, safety, or welfare of the cooperative residents or other persons, and that such guidelines provide reasonable and meaningful notice to the public of likely penalties that may be imposed for prescribed conduct. This subsection does not limit the ability of the division to informally dispose of administrative actions or complaints by stipulation, agreed settlement, or consent order. All amounts collected shall be deposited with a chief financial officer to the credit of the Division of Florida Condominiums, Timeshares, and Mobile Homes Trust Fund. If a developer fails to pay the civil penalty, the division shall thereupon issue an order directing that such developer cease and desist from further operation until such time as the civil penalty is paid, or may pursue enforcement of the penalty in a court of competent jurisdiction. If an association fails to pay the civil penalty, the division shall thereupon pursue enforcement in a court of competent jurisdiction, and the order imposing the civil penalty or the cease and desist order shall not become effective until 20 days after the date of such order. Any action commenced by the division shall be brought in the county in which the division has its executive offices or in the county where the violation occurred. The division may prepare and disseminate a prospectus and other information to assist prospective owners, purchasers, lessees, and developers of residential cooperatives in assessing the rights, privileges, and duties pertaining thereto. The division has authority to adopt rules pursuant to SS 120.5361 and 120.54 to implement and enforce the provisions of this chapter. G. The division shall establish procedures for providing notice to an association when the division is considering the issuance of a declaratory statement with respect to the cooperative documents governing such cooperative community. H. The division shall furnish each association which pays the fees required by paragraph 2 a copy of this act, subsequent changes to this act on an annual basis, an amended version of this act as it becomes available from the Secretary of State's office on a biennial basis, and the rules adopted thereto on an annual basis. I, the division, shall annually provide each association with a summary of declaratory statements and formal legal opinions relating to the operations of cooperatives which were rendered by the division during the previous year. J. The division shall adopt uniform accounting principles, policies, and standards to be used by all associations in the preparation and presentation of all financial statements required by this chapter. The principles, policies, and standards shall take into consideration the size of the association and the total revenue collected by the association. K. The division shall provide training and educational programs for cooperative association board members and unit owners. The training may, in the division's discretion, include web-based electronic media and live training and seminars in various locations throughout the state. The division may review and approve education and training programs for board members and unit owners offered by providers, and shall maintain a current list of approved programs and providers and make such list available to board members and unit owners in a reasonable and cost-effective manner. L. The division shall maintain a toll-free telephone number accessible to cooperative unit owners. M. When a complaint is made to the division shall conduct its inquiry with reasonable dispatch and with due regard to the interests of the affected parties. Within 30 days after receipt of a complaint, the division shall acknowledge the complaint in writing and notify the complainant whether the complaint is within the jurisdiction of the division and whether additional information is needed by the division from the complainant. The division shall conduct its investigation and shall, within 90 days after receipt of the original complaint or timely requested additional information, take action upon the complaint. However, the failure to complete the investigation within 90 days does not prevent the division from continuing the investigation, accepting or considering evidence obtained or received after 90 days, or taking administrative action if reasonable cause exists to believe that a violation of this chapter or a rule of the division has occurred. If an investigation is not completed within the time limits established in this paragraph, the division shall, on a monthly basis, notify the complainant in writing of the status of the investigation. When reporting its action to the complainant, the division shall inform the complainant of any right to a hearing pursuant to SS 120.569 and 120.57 N. The division shall develop a program to certify both volunteer and paid mediators to provide mediation of cooperative disputes. The division shall provide, upon request, a list of such mediators to any association, unit owner, or other participant in arbitration proceedings under S. 718.1255 requesting a copy of the list. The division shall include on the list of voluntary mediators only persons who have received at least 20 hours of training in mediation techniques or have mediated at least 20 disputes. In order to become initially certified by the division, paid mediators must be certified by the Supreme Court to mediate court cases in county or circuit courts. However, the division may adopt, by rule, additional factors for the certification of paid mediators, which factors must be related to experience, education, or background. Any person initially certified as a paid mediator by the division must, in order to continue to be certified, comply with the factors or requirements imposed by rules adopted by the division. 2C. A cooperative association shall create and maintain an online account with the division as required in subsection 3. 3. On or before October 1, 2025, all cooperative associations shall create and maintain an online account with the division and provide information requested by the division in an electronic format determined by the division. The division shall adopt rules to implement this subsection. The division may require cooperative associations to provide such information no more than once per year, except that the division may require cooperative associations to update their contact information in paragraph within 30 days after any change. The division shall provide a cooperative association at least a 45-day notice of any requirement to provide any required information after the cooperative association creates an online account. The information that the division may require associations to provide is limited to the contact information for the association that includes all of the following. 1. The name of the association. 2. The physical address of the cooperative property. 3. The mailing address and county of the association. 4. The email address and telephone number for the association. 5. The name and board title for each member of the association's board. 6. The name and contact information of the association's community association manager or community association management firm, if applicable. 7. The hyperlink or website address of the association's website, if applicable. B. The total number of buildings, and for each building in the association, 1. The total number of stories of each building, including both habitable and uninhabitable stories. 2. The total number of units. 3. The age of each building based on the certificate of occupancy. 4. Any construction commenced on the common elements within the previous calendar year. See the association's assessments, including the 1. Amount of assessment or special assessment by unit type, including reserves. 2. Purpose of the assessment or special assessment. 3. Name of the financial institution or institutions with which the association maintains accounts. D. A copy of any structural integrity reserve study and any associated materials requested by the department. The association must provide such materials within 5 business days after such request in a manner prescribed by the department. This concludes the readout of pages 67 through 79 of the comprehensive 92-page Florida House Bill 913 PDF document. To view the text directly, please visit flsenate.gov/session/bill/2025/913 or alternatively laws.flrules.org/2025/175. Thanks for watching. For full access to our comprehensive reports, statistical charts, virtual monthly meetings, and exclusive meetup events, we invite you to join the Miami Condo Investing Club at Miami Condo Club. The club's mission is to foster a community that shares real-time, actionable intelligence on the latest real estate trends, emerging opportunities, and trusted service providers throughout South Florida. Whether you are a do-it-yourself DIY condo buyer or a seasoned real estate professional, the club provides invaluable resources, including up-to-date statistics, expert analysis, and access to tailored consulting services. An added benefit of the club is that members receive discounts on all Miami Condo Correction walking tours. Please visit miamicondoclub.eventbrite.com for a schedule of upcoming tours. To view additional videos, please visit Miami Condo Club. This concludes our video.